PowerPoint and we will get started. That looks great. Thank you so much. So Laura and Katie.
Good morning, everyone. Thank you so much for joining us. If you can't hear, please put it in the chat. Thank you for having us, Baker and McKenzie. We're very excited to be here. And so today we'll be talking about representing immigrant survivors of domestic violence and other types of qualifying crimes. My name is Laura Garcia Saguirre. I am the project supervisor for NIJC's Our U Visa Pro Bono project. And
I am Katie Myopoulos, and I am the VAWA U Visa Pro Bono project coordinator. Thanks so much for being here.
Okay, so we have quite a bit to get through today, but I just want to start by giving an overview of NIJC's approach, and someone to help talk about our pro bono projects is Baker and McKenzie's very own Angelique, who's here to share a few words about working with our project.
Hi, everybody. My name is Angelique Porton. I'm an associate in the Chicago office, and I'm a member of the Pro Bono Committee. As you can hear from my lovely accent, I'm not quite from here, so I'm an immigrant myself. I went through the visa, the renewal, the green card, the naturalization process. So I've always wanted them to give back and help people who were going through the same type of immigration process. I know how stressful it can be. I knew I could not help victims of domestic violence with the difficult times they were going through, but I could help them through that process. And way back when, like years ago, I helped one family from Guyana to get a permanent status in the US. It was a woman with her 3 kids, victims of the husband's violence. So it was at a point where she fled Guyana. He followed her. It came to the US, and that's when Baker and McKenzie got involved. We helped her and her 3 kids to get the status here. And what was really nice, this happened when I was in New York, and so I moved to Chicago, and she actually tracked me down. When all was done, they were all safe in the US. They all got their visa. She tracked me down just to give me an update how her life was going, and her son, who was 7 at the time, who was now a teenager, was thriving in school and was now more balanced and was getting out of the depression that he had to go through because he had seen his mom being beaten by his dad. He was also threatened by his dad. And I thought, okay, this is all worth it to build that relationship with people and seeing that you really make an impact on their lives and that they're now doing fine. So I'm happy to continue to work with NIJC.
Thank you so much.
Thank you.
Okay, so what does NIJC do? So NIJC is a national organization that focuses its efforts on 3 main types of work. We provide direct services for non-citizens. We also do national and local advocacy through policy work, and we have a federal litigation group. And pro bonos make up a huge part of the work we do. They help increase our capacity. And currently we're working with over 2,000 pro bono attorneys on a variety of different cases. And so we're very thankful for all of our pro bono partners who help us do our job. And okay, so today specifically, we are going to be talking about our different pro bono projects. We will then dive into U non-immigrant visas, which we'll be referring to as U visas for short moving forward. Then we'll have a portion on what it's like to work with survivors of domestic violence and other types of violent crime. Then we'll get into the nitty-gritty of preparing a U visa. What are the steps that you need in order to prepare your case? And we will end with some references, contact information, and if time allows, some case examples as well. So diving into NIJC's pro bono projects, we do have a variety of projects at NIJC. There is an asylum project, a detention project that works with people in immigration detention, a litigation project, a special immigrant juvenile project, our project, which is the VAWA U Visa project, and we also have 2 clinics that offer assistance to people that need to renew DACA or people who are applying for citizenship. And it's possible some of you have worked with us on other projects and you want to dive into U visa work, or maybe you're just interested in our work in general. But if you have any questions about any of these projects, feel free to reach out to any of the people here, either Katie, myself, Trisha is also here. She's our project manager. And then we also have Ellen and Demetrius that can also help you if you have any questions. So what does it look like to work with NIJC as a pro bono partner? So the first step is on NIJC's part. We meet with potential clients, do an in-depth consultation with them to assess, first of all, if they have an avenue for immigration relief. Second of all, if it's a type of relief that we can assist them with. And third of all, if it's a type of relief that we can assign to a pro bono partner. So once we've made that assessment, we explain this process to the clients. We let them know what our pro bono project is, rights, responsibilities, and then we get in touch with pro bono attorneys. We send them a case blurb that has a brief description of the case, and anyone interested in working on the case then contacts us, and we work with them to assign them to the case that they're interested in taking. So it's a bit of a, all of the projects have the same process for assigning cases, and it is a bit of a process with NIJC being the initial point of contact with the client. So I talked about roles and responsibilities earlier, but let's dive in deeper into the parties involved in pro bono projects and what each of us are committed to doing. On NIJC's part, big picture, we provide outreach trainings like this one, where we just do a general introduction to the types of work we do. We screen clients, we work with community partners to increase the number of clients that we're meeting with, or the number of prospective clients. And then on a more micro level, individually with pro bonos, we prepare the case for placement, which means we create a case referral packet. A lot of the information that we are going to be reviewing today about the intricacies of a U visa and the more case-specific details are part of this case referral packet, which we send to pro bonos once the case is assigned. And then throughout the duration of the case, we provide technical advice, we provide drafts, we review drafts, we provide updates on laws and policy. And for people who might be coming from smaller firms, solo practitioners, or people just reactivating their license, we also provide malpractice insurance when needed. And we will remain of counsel for the duration of the case, but it is the pro bono attorney who represents the client before the government. So what are the rights and responsibilities of pro bono attorneys? So the first step is to pick a case and run a conflicts check to make sure that it's a case that you can work on. Then you are responsible for preparing the case, meeting with the client, filling out the forms, putting together the evidence. You're also responsible for providing translation and interpretation if needed. If that's the case, we'll let you know if you need an interpreter. And finally, the pro bono is responsible for keeping NIJC updated regarding the case. So anything as simple as the client moved houses to anything as big as we received this letter from immigration, we don't know what it means, please help us. So we will be there every step of the way to provide guidance. And then lastly, the client. So first and foremost, the client has the responsibility of being truthful in their accounts. And a lot of that has to do with building trust with the client and making sure that the client feels comfortable sharing some of these details with the pro bono attorney. The client is also responsible for updating their attorney on anything that might have happened in their life. Change of address, marriage, arrest, anything like that might be relevant to their case. And so they know that they should report any change to their attorney. And that's pretty much it. This is an ongoing relationship, and communication is a really important part of ensuring that everything works out smoothly. When in doubt, you're always welcome to email any of us on the team for assistance. And this next slide just kind of like provides an overview of the type of more technical assistance we have. So our website is a great resource for pro bono attorneys. We have sample filings, sample briefs, how-to practice manuals there. It's slide number 8 for those of you that are looking at the PowerPoint. And we provide latest policy updates. And so our website is always a very good first place to check if you ever have questions about the type of process that you're working on. And we do have more tailored samples depending on the stage at which your case is at. Okay, so now I'm going to turn it over to Katie.
Thanks so much. So now we'll be getting into the focus of our training today, which is the U visa. And in this section, we'll be talking about the purpose of the U visa, its benefits, the requirements, and then at the end, we will have time for a case example. So first to start out, what is the U visa? The U visa was created in the year 2000, and the purpose of this visa is to strengthen the ability of law enforcement agencies to investigate and prosecute cases of a variety of crimes. We can imagine that if victims do not have legal status, they may be reluctant to reach out to law enforcement agencies in the investigation or prosecution of such crimes. So the U visa increases victims' willingness to come forward, to report crimes, and then to help in the prosecution of such crimes. So we can go on to the next slide where we talk about the different actors involved in a pro bono U visa case. So the first actor involved would be the client or the family. So this may include the survivor of the crime or those who were indirectly victims of the crime, or also perhaps derivatives, which we'll talk about later. The pro bono attorney and NIJC work in conjunction, as Laura was describing. So NIJC screens the client, and we also assist the client in gaining any necessary documentation. And the pro bono is the attorney of record throughout the application process and its adjudication. USCIS adjudicates the U visa and any relevant applications that are filed alongside it. And then the law enforcement agency oftentimes might be a police department, for example, and they certify a form that is necessary to be eligible for the U visa. And they also work with the victim on cooperation and helpfulness. So in terms of benefits and limitations that accompany the U visa, there are several. So some of the first benefits that may become available to an applicant are non-immigrant legal status and employment authorization for up to 4 years. It is also a potential path toward permanent residency and perhaps eventual citizenship. And certain family members may qualify as derivatives. And also in certain states, they may be eligible for certain public benefits. In terms of limitations, the victim is prohibited from including as a derivative on the application any family member who committed the qualifying crime. There's also an annual cap of 10,000 U visas per fiscal year. This has resulted in long processing times, and to give you an idea, right now, U visa applications that were filed in May of 2016 are being adjudicated. So it's a very long processing time. And so it may take several years for an applicant to actually begin receiving some of these benefits that are on the left-hand side. But there are many benefits that come along with it. In addition to the principal applicant, several people may be able to be included as derivatives. And so this all hinges on the question of how old was the victim at the time of filing the U visa. I should say that derivatives may be in the United States or they may be abroad. So to start on the right-hand side, if the victim is over 21 years old, perhaps as derivatives, you could include unmarried children under the age of 21 or spouse. If the victim is under 21 years old, derivatives might include parents, siblings under 18 years old, unmarried children under 21, or their spouse. When NIJC does refer a pro bono case, we always screen for derivatives at that time. And so we'll let you know if someone intends to include their spouse as a derivative or perhaps their children. And we also are involved in conversations if a derivative becomes eligible, let's say someone becomes married throughout the processing time, we would also have that conversation with you. In terms of the standard of proof, the any credible evidence standard applies to U visa petitions. So we will continue on to the next slide where we talk about the definition of a victim. So there are direct victims and indirect victims. A direct victim is the person who is directly and proximately harmed by the qualifying criminal activity. This could also include bystanders or those who witness a violent crime and then suffer unusually in a direct way. So for example, that might include a pregnant woman who witnesses a violent crime and miscarries. That would be included under bystanders. Indirect victims, if a victim is murdered or is incompetent or incapacitated, then perhaps people who could be qualifying for a U visa might include an immigrant spouse, children under 21 years of age, parents, siblings. Indirect victims could also be those who are the victims of witness tampering, obstruction of justice, or perjury, or also next friends might qualify as indirect victims. So those who are appearing in the lawsuit to act on behalf of anyone who is incompetent or incapacitated or under 16 years old and who has suffered the qualifying crime. So next, we will move into the 4 requirements that all principal applicants for the U visa must prove. This does not apply to derivative applicants. This is solely for the principal applicants. So the first requirement is that the immigrant has suffered substantial mental or physical abuse as a result of having been a victim of a certain qualifying crime. So to break this into 2 parts, not all crimes would qualify for a U visa. We'll be getting into that list on the next slide. The second part of this is that they have suffered substantial mental or physical abuse. And we will also be looking at that definition later on and what would qualify to meet that standard. The second requirement is that the immigrant has been helpful, is being helpful, or is likely to be helpful to a federal, state, or local authority investigating or prosecuting the crime. So, right, going back to its original purpose of assisting law enforcement to investigate and prosecute crimes, it's important that the applicant is willing to be cooperative and helpful. The third requirement is that the immigrant possesses information concerning that criminal activity. And we'll also be getting more into exactly what information that is referring to a little later on. And the last requirement is that the criminal activity violated US law or that occurred in the US. So now we're going to dig a little bit deeper into these 4 requirements. So the first one, that the qualifying criminal activity does in fact qualify the survivor for the U visa. The crime must include or be similar to any one of the following here in this list. This also could include attempts, conspiracy, or solicitation to commit any that are here. So as you can see, there are many that are qualifying crimes. Often at NIJC, our pro bono cases center around domestic violence or felonious assault from this list, although we do see several of the other ones. So as you can tell from this list, these are serious, egregious crimes. They can be difficult to discuss and talk about. And NIJC also provides trauma-informed resources so you can best have those conversations with your client as you're discussing these really serious crimes. Our clients seek the U visa as part of a process of healing, finding stability, and finding peace after such a traumatic event. And so you can think of your role as Angelique mentioned, as assisting them on that path towards stability and peace in the aftermath. And we'll be discussing more about working with survivors of domestic violence and other crimes a little bit later on. So going back to that first requirement, now we'll get into the second part of it, which is that based on that qualifying crime, the survivor has suffered substantial physical or mental abuse. And so here, no single factor is a prerequisite. USCIS can consider a series of acts. So we might consider, let's say, for a survivor of domestic violence, that often occurs in a cycle. There's a history there. So we could look at a whole series of events that the survivor has survived to show USCIS exactly the substantial physical or mental abuse. And looking at the definition specifically, it is defined as injury or harm to the victim's physical person or harm or impairment of the emotional or psychological soundness of the victim. So there are many different kinds of abuse that can be highlighted in a U visa application. So USCIS considers the nature of the injury or harm, the severity of it, of the conduct and of the harm itself, and also the duration that that harm was inflicted upon the survivor. To return to the second requirement, that is cooperation with law enforcement. So the applicant must have been helpful in assisting law enforcement in the investigation or the prosecution of the qualifying criminal activity. And they also carry an ongoing responsibility to be cooperative and to be helpful should that assistance be ongoing. USCIS does exclude from eligibility those who, after even initial cooperation, if they refuse to assist further, that can also impact their eligibility. So you'll see here we have this big orange sign that says, please carefully review I-918 Supplement B and any police report documents. So this Supplement B is the form that is certified by a law enforcement agency. We'll be getting more into it a little bit later, But I want to let you know that NIJC always screens these documents. We look closely to see what law enforcement has marked and indicated in terms of helpfulness or cooperation. At times, we may even be able to assist at the same time with advocacy around the certification of this form. If, let's say, law enforcement has indicated an applicant has not been helpful, but it appears that they have been, we can also assist with that at times if we believe that they have in fact been helpful, because it is a really big part of the visa process. To go on to the third requirement, this deals with possession of information. So the individual must have knowledge of the details of the qualifying criminal activity that would assist in the investigation or the prosecution of the crime. And again, a next friend or a parent or guardian can play this role if the victim is less than 16 years old. So this may include a description or the identity of the perpetrator, the location of the crime, if a car was involved, perhaps the description of the vehicle. So all of those details, so that way law enforcement can further investigate and prosecute the crime. So to demonstrate this helpfulness and cooperation, the U visa certification, Form I-918 Supplement B, is a requirement for each U visa application. And so here that is completed and signed. It can be completed and signed by a few different people. The head of a certifying agency, so often a police department, as I mentioned before, but it could also be any person specifically designated by the head of the agency to sign the certification, or sometimes even a federal, state, or local judge. A really important practical information here is that the certification must have been signed within 6 months immediately preceding the submission of a U visa application. So once this form is signed, the clock starts ticking, and the application must be filed within 6 months of that signature. The original certification is required to show cooperation with law enforcement, so it is included in the filing. So when NIJC refers a case to you as the pro bono attorney, you will work with that client to gather the original U visa certification and include that in the application. So another requirement for an approved U visa is admissibility. So all U visa principal or derivative applicants must be admissible to the US, or they must seek a waiver of inadmissibility. So for example, U visa applicants may need waivers for these common grounds of inadmissibility that you see below, like an entry without inspection. So like an entry without a visa, for example, into the United States, or for any one of these things that you see here. The U visa provides for a very generous waiver. And when we make the referral to you, we identify all of the grounds of inadmissibility that will need to be waived during the process. There are a few grounds that cannot be waived, even though this is very generous. And that includes those who have participated in Nazi persecutions, genocide, acts of torture, or extrajudicial killings. To get a little bit more into the nitty-gritty of the waiver, the form that is used is Form I-192, and this is based on discretion. So here it's necessary to prove all of the positive factors an applicant may have and why it is in the national or public interest that this waiver be granted. And so here you may want to consider these things with an applicant: evidence of rehabilitation if necessary, reasons why they wish to remain in the US, highlighting perhaps businesses they own, family members they have who are citizens or permanent residents. Jumping down to the last bullet point, it may be helpful to demonstrate why it's necessary they remain in the US to receive medical treatment if they have a longstanding illness or if one of their children does. And so all of this would work with the client to best argue why it is in the best national public interest for this waiver to be granted. Here you'll notice at the bottom, this application, the waiver, does carry a fee. It is $930. And so it's necessary for the applicant to pay that or request a fee waiver. And NIJC works with the client to gather fee waiver documentation if that is necessary. So the U visa application itself is free, although this waiver carries a cost with it. The U visa also comes along with several confidentiality provisions, and this is really to protect applicants. And so, for example, all DHS and DOJ employees are prohibited from providing information about U visa applicants to third parties. So when you as a pro bono attorney are the attorney of record on the case, you take on the case, you will be receiving all correspondence from USCIS. So it's really important to have your address up to date and to make sure that you're keeping an eye out for any correspondence, because the applicant will not be receiving any correspondence at all from USCIS. Additionally, there are prohibitions against the abuser from providing information about the applicant. So that cannot be used in any way to inform the U visa process on behalf of the applicant. So as we mentioned before, there are really long processing times with the U visa. And so as the pro bono attorney, it's important that you keep your eye out for notices, but also understand there may be years and years where you do not hear from USCIS. But we work with you to also, you can submit inquiries and check on the case if you think that you may perhaps have missed a notice. So now we'll be getting into a case example. So we can really go through one and see if this applicant perhaps would meet the 4 requirements. And we'll also talk about grounds of inadmissibility that may come up. So as I read through this case example, please keep your eye out for the 4 requirements. What is the qualifying crime? Has the applicant shown cooperation or helpfulness? Would they have information about the crime? And did it take place in the US? So Ana is a Mexican citizen who entered the United States without inspection in 2010 with her 1-year-old child. In 2012, Ana married Juan, who was undocumented, and the couple later had 2 US citizen children. During the marriage, Juan did not let Ana leave the house without his permission. He controlled all the money and often threatened to have Ana deported. On one occasion, Juan repeatedly hit Ana and she called the police. Juan fled before the police arrived. Ana filed a police report, but Juan was never arrested. Thereafter, she took the children to a domestic violence shelter and obtained a civil order of protection. She is seeking a divorce. Juan continues to call her and threaten her. So there's a lot of information here. Let's break it down. So what might be the qualifying crime here in Ana's case? Feel free to go back to that list of qualifying crimes.
Hostage.
Hostage, okay. Any other crimes come to mind? Domestic violence. So, Demetri, when you said hostage, like in terms of he would not let her leave the house.
Mm.
So when you say domestic violence, can you tell me a bit more about what led you to it? What actions here would make it fit under domestic violence?
Yes, so repeatedly hitting her and threatening behavior, controlling self.
Absolutely right. He hit her. He controlled all the money. There were threatening behavior. Like Demetria said, Juan did not let Ana leave the house. All of those would fall under those series of acts to meet domestic violence as the qualifying crime. So here, has Ana been cooperative with law enforcement? Has she been helpful towards them in any way? Has she reported the crime? I see head nodding from the folks we have in person. Yes, she has called the police. She filed a police report. Is it an issue that Juan was never arrested, that he fled before law enforcement got there? Would that negatively impact Ana's case? I see shaking. I see shaking. Yes, you're right. She's cooperated. She's been helpful. She has filed a police report. And so again, coming back to the requirement that you be helpful in the investigation or the prosecution. So she has already met that. Does she have information about the crime for law enforcement? Right, she knows the identity of the perpetrator and she's able to give that information. And we can assume that it took place in the United States. Yes, Trish.
Good question. So based on the list of qualifying crimes, could somebody qualify for like false imprisonment and domestic violence in one
At the
case?
same time? Yes, you can have multiple qualifying crimes. And so when the law enforcement agency checks them off, they can check off 2 different crimes at the same time. There also is some stalking and harassment here at the bottom. Juan continues to call and threaten her. Let's say that she were to file another police report. That also may lead to other qualifying crimes as well there, or it could fit under the same umbrella of domestic violence. I want to include a few other things here. Ana would be our principal, but can we identify any derivatives here? Is anyone eligible perhaps? Yes, who all do you see perhaps? Yes, go ahead. Right, her children. She entered without inspection in 2010 with her 1-year-old child. So at this time, this child is probably about 13 or 14 and could qualify as a derivative. I want to come back to her 2 US citizen children as well. Anna has a few grounds of inadmissibility that she will need waived. What are those grounds of inadmissibility? Entering without inspection, great. Is there anything else that might show up?
There's one online here that says child smuggling from Ingrid.
Right, thank you so much, Ingrid, online, absolutely. So here she entered with her 1-year-old child. That would be smuggling a relative into the country, and so she will probably need those 2 grounds waived. So if this were an NIJC referral, we would let you know. Anna will require a waiver, and she will need to waive these grounds. Just briefly to touch on some mitigating factors that maybe she can bring up. Her 2 US citizen children are ties to the United States that she can bring up, that she needs to, she cares for them, and also like she is the main caretaker of them right now. They're in a domestic violence shelter, and so she can use those to show positive discretion with that application. I don't know if there's any other questions here in the room or online about the case example before we go on to working with survivors of domestic violence.
I have a question about this case. Say if a victim or an applicant has proof of like the crimes, but was scared to actually go to the police or didn't go to the police, how does that affect like their applicancy?
That's a really good question. So it is necessary that an applicant do file a police report. Part of the basis of the U visa is they work with law enforcement agencies to prosecute or investigate the crimes. So unfortunately, if there has not been contact with law enforcement, that would present an issue. There may be other kinds of applications they may be eligible for, but the U visa itself does hit on that.
Is there a, I would not say like hierarchy of crimes, but if like seriousness of crimes when it comes to like if she's called the police one time, but there are other victims that have called multiple times or had like more serious threats, would their case take precedence over hers?
I can take that one, yeah. So no, as long as they meet each of the 4 requirements, they show cooperation, and they were a victim of a qualifying crime, then the USCIS adjudicator will just look at the checklist and check everything off. In cases where maybe they only called the police once, or maybe it's a crime that, you know, the attorney might need to do a little bit more advocacy to say, yes, this was felonious assault, and make some arguments. We would work with the pro bono to kind of bolster the case in that sense. But in terms of severity, the adjudicator should be looking at everything based on the standard that was in one of the previous slides to make sure that they're eligible.
There's a question from the chat. If one was never found or prosecuted, does that have an impact on the U visa application?
No, it Anna did her part by reporting the crime and speaking to law enforcement. If one got away, that won't affect Anna, unless of course the police came back and talked to her and asked her, where do you think he might be? You know, all these follow-up questions, and she unreasonably refused to provide that information. But generally speaking, it doesn't matter if the case isn't prosecuted, if the perpetrator or offender isn't arrested, as long as the victim reported the crime.
Great questions. Do we have any others before we move on to the next section? Okay, then we will keep making progress. We are now going to move into a section about working with survivors of domestic violence. As I mentioned before, many of NIJC's referral cases do center on domestic violence as a qualifying crime, but any one of these trauma-informed approaches or understanding can be helpful for working with survivor of any crime that we might see. So here on our first slide, we'll be discussing how abusers exert power and control. And so here we have a few different elements of the way that domestic violence may present itself. So here we have citizenship or residency privilege, using that to create a power imbalance, emotional abuse, economic or financial abuse, like we saw in our case example, sexual abuse, physical abuse, threats, intimidation, and isolation. So all of these can be a part of the cycle or history of domestic violence. And again, this can come back to there being a series of actions that USCIS can consider in the adjudication of a case. Also, this is really helpful for you all as pro bono attorneys to understand so that you can best help present the client's case and include this information in the affidavit, perhaps if a client is not sure if something would be considered part of the domestic violence that they suffered. So if we could click on this slide, it'll bring up a few smaller examples. And I want to highlight a few that perhaps may not be as visible often. I think in terms of media or knowledge that we previously may come to this space with, we may have heard a lot about physical abuse or threats or intimidation. And there's a few others I'd like to highlight. So for example, up here at the top, abusers may fail to file papers to legalize a victim's immigration status. They may hide or destroy important papers, perhaps from an applicant's home country. They may isolate the victim from family or friends, and they may also exert financial isolation or manipulation to further control the applicant. So these are all things that may not be as commonly seen, but I do think that they're important to recognize. They can come in a few different forms. So next we'll touch on the cycle of abuse. There are three main stages in the cycle of domestic violence. The first is the honeymoon phase, the next is the tension, and then the last is the explosion. And these move around in a cycle. So oftentimes a relationship may start out loving and affectionate, and then we may enter the tension phase. So if we can click on the next slide where we have a few more details. So oftentimes the tension phase is one of minor incidents. And this can feel like tension is mounting between the survivor and the abuser. The survivor may walk on eggshells, feel like they're really trepidatious. They're trying to make sure that there's no flare-up that's going to happen. But the victim cannot control the situation. It's truly out of their hands. And this is often the longest phase. When the explosion occurs, that would be a serious incident of domestic violence. Definitely an escalation. This is the shortest phase, but this becomes more frequent and more intense as the cycle continues. And in this phase, the abuser may seem entirely different than they were at the beginning. They may seem entirely out of control. And so then it comes back into the honeymoon phase, and oftentimes the abuser will try to smooth things over. As we see here, chocolate and flowers, maybe making grand gestures, promises that their behavior will change. And they may ask for forgiveness and act truly sorry. And so here I think it's helpful to understand perhaps this cycle to better be able to present clients' cases in front of USCIS, but also to approach things with much empathy for our clients, because at the center of all of this is a sense of denial and a sense of hoping that things will get better, because perhaps at one point there truly was a good relationship at the foundation, but things have since changed. And we end up in this cycle. So to go on to the next slide, there are a few specific barriers that immigrant survivors of domestic violence may face. For example, language limitations. So this may make it more difficult for a survivor to reach out for help or assistance, or let's say they do call the police and the police show up but don't speak their native language. Perhaps only the abuser will be interfacing with the police. So those are things to consider in terms of language limitations. They may be facing extreme isolation. Perhaps their entire community and network is still in home country, and they are here and their abuser is one of the only people that they know. Or perhaps they're confined to working within the home and they don't have the opportunity to interface with other people. There can also be cultural ideas of abuse that present barriers for survivors. So perhaps what is permitted, what is taken to be the norm, quote unquote, within a marriage or a relationship. Gender roles can also play into this. There may be cultural ideas of family shame and honor, like what does it mean to be a good spouse? What does it mean to be a good wife, for example? There may also be close-knit communities where breaking apart from a relationship might cause a fissure within a greater social structure that can be intimidating for survivors. And then lastly, the role of religion. So is divorce frowned upon? Is leaving a marriage or separation frowned upon, even if there's violence that is present? So those are all things specifically that immigrant survivors of DV may be facing. And last, to touch on how abusers can misuse immigration privilege in creating a power dynamic between them as a person with illegal immigration status and perhaps their undocumented partner. So they may fail to file immigration papers on behalf of a family member, or they may file an application and withdraw it or threaten to withdraw it. They may threaten to contact immigration officials, or they may actually contact immigration officials to attempt to report their family member, or they may provide immigration officials with false information about family members. And that, again, is why the U visa does have confidentiality provisions to protect against these attempts to misuse this immigration privilege. So that was a lot of information, and we have reached a quick pausing point. At this time, I'm going to give the first CLE word. So the first CLE word is cooperation. So again, our first CLE word is cooperation.
And we may have forgotten to say this at the beginning, and I apologize, but we will be sending out a survey after today's presentation where you'll be asked to answer a few questions and enter the 2 codes that we'll be giving throughout the presentation. And you will have to fill out the survey in order to receive a certificate or CLE credit.
So at this time, we're now going to be taking a 10-minute break. So for folks in person to use the restroom and get lunch, and for our folks online to also take a stretch and get whatever you need. And so we'll be coming back at noon, just about at noon, at 12 CST.
So, thank God, I would, that's.
What is the hour? That's right. You ready? You want to get started?
Okay, welcome back, everyone. Thank you so much for joining us today. And just a big thanks again to Baker and McKenzie and Melissa Alchin for hosting us today. So,
just want to make sure everybody's okay. You have everything you need.
yes,
Thank you. Thank you.
Thank you.
okay. So before the break, we talked about working with survivors of domestic violence and other violent crimes. Right now, we're going to switch gears and talk more specifically about preparing a U visa case, what goes into a filing, how to work with clients. And then we'll take it from there. So you have picked a case, you've run the conflicts check, you've been assigned to work on a case. So what's next? NIJC will send you the referral packet, which will have a whole lot of information in it, a whole lot of documents that you'll need in order to prepare the case. But the very first step that you will need to take as a pro bono attorney is to reach out to the client, introduce yourself, and from the very beginning, it's really important to start building trust with that client. As Katie was mentioning earlier today, these clients have already been through a lot, and they are unfamiliar perhaps with the criminal justice system, with the immigration system, and just generally with processes in the US. And you will be their guide through, at the very least, the immigration process. And so it's very important to start building that trust from the get-go. Some things to keep in mind and help build that trust is being very aware of how you reach out to the client, if you're meeting in person, perhaps the space you're in, will you have tissues or water available? What are some things that you can do to make the client or clients feel comfortable during that first meeting? It's also really important to explain your relationship with NIJC. So up until that point, they will have been in communication with people from NIJC. They're familiar with our work, and we will have already explained to them what our pro bono project is, who we are assigning the case to, but it's also always helpful to also hear that from you and maybe explain, you know, what the firm is, your role at the firm, and what your role is in their process. A third step, particularly with working with survivors of domestic violence, is setting up a communication plan. So a client might have a preferred way of communication. A client may also have a safer way of communication. So if they still live with the perpetrator or the abuser, they may not want you calling them. Maybe their phone is being checked by their abuser, or maybe you're working with a client who lives in downstate Illinois and they might prefer phone consultations as opposed to coming in person. And so these are all things that you can work with during that first meeting. And also, we will let you know if any clients need interpretation and what their preferred language is, so that you can also be ready if needed with an interpreter for that initial either call or consultation meeting with your clients. And then another thing that's very important to do during that initial meeting is to explain the process. So the client already knows that they're eligible for a U visa. They will already know if they need a waiver of inadmissibility. But this is also an opportunity for you to again explain what that process is, set some expectations. As we've mentioned, the U visa is, you know, one of the immigration processes that probably takes the longest. We're looking at about 8 years for adjudication. And so it's really important to kind of set some of those expectations with the client so that they know, you know, what they're getting into, and that this is a relationship that they'll be starting with you that will, you know, last several years. You can go over the document list. You can share them what we've given to you in the referral packet, so we know what you have. And they may also be bringing new documents to you. For example, the law enforcement certification, the referral packet will have a copy of it, but they should be bringing the original to you or sending it to you, whichever way you meet with them. And it's also an opportunity for the client to ask questions. And so one thing that's important to note here is that as the pro bono attorney, your responsibility is to prepare and file the U visa case, but anything that might fall outside the scope of preparing the U visa application is something that you can reach out to us for assistance on. So clients might ask about public benefits. They might ask, well, I want to get divorced? How do I do that? For all of those questions, you can just refer them back to us, and then we'll refer them out to other agencies that can assist with those more other types of legal questions that they might have that fall outside the scope of immigration. So that's your first meeting with the client. U visas, as I'm sure you've noticed by now, are pretty front heavy. In other words, the adjudication times are very long, but most of the work goes into preparing the application. And once it's filed, you're pretty much just waiting to receive news from immigration. But it does take time to prepare the application. And so you will need probably at least 2 meetings with the client in order to prepare the application. And you'll need 2 meetings for a variety of reasons. First of all, there's a lot of forms and documents that you're going to be reviewing with the client. And second of all, clients may not be ready to speak about the crime that they were a victim of at the very first meeting. They may need some time to warm up to you to build that trust, or maybe they're willing to talk about that, but maybe they need to take breaks. You might need to cut the meeting short depending on what their emotional state is during those meetings. And so just be prepared to have more than 2 or at least 2 meetings with your clients. I will say a lot of the forms, the immigration forms that you'll be filling out, ask a lot of similar information. And so once you start working on one, it's just, you get in a groove and you just go through the questions. And it's also helpful for the clients to understand that the questions you're asking aren't because you don't believe them or you're questioning them, but rather because they're the questions on the immigration form. And so if they can see that you're filling that out, that'll go a long way towards building trust with the client. Okay, so what are some types of evidence that you'll be including in the application packet? So everyone, whether they're a principal applicant or a derivative, will have an affidavit. So for U visa specifically, there is no hearing before an immigration judge. There's no interview before an immigration officer. Everything that you file, that's it. And so the affidavit is the client's likely only opportunity to tell the story from their perspective, to let the officer know what their life is like, why they want to stay in the US, what their goals are for living in the US, and why they are unable to go back home, or what would be the risks if they had to return to their home country. And so this is an affidavit that you will work on with the client. In some cases, clients already prepared a draft. In other cases, clients might want to work with their counselor or therapist on this affidavit. And in other situations, the client might want you to work with them on this. We have sample affidavits. We have sample letters to counselors that we can provide you if the client prefers to work with their counselor. But this is a very important piece of documentation. The second piece of evidence that you'll have to include is identity documents, just to prove the client's identity, so USCIS knows who the applicant is. Third, you'll want to include documents supporting their U visa eligibility. So the police report where the crime is reported. If they got an order of protection or some other kind of civil document, you'll want to include that. Let's say they were the victim of felonious assault and had to go to the ER after the crime. You'll want to include documents from the ER, perhaps a doctor's letter explaining what the physical harm was, or in cases where the substantial harm was more psychological or mental, you might want to include a letter from like a counselor or have a psych evaluation done so that the counselor can go into the type of emotional or psychological harm. And then lastly, if the client is inadmissible and needs a waiver of inadmissibility, then you'll also have to include documents in support of that waiver of inadmissibility. As we mentioned before, this is a discretionary application. And so the client will need to work to gather positive discretionary evidence to show why they merit that favorable exercise of discretion. Almost all, if not all, documents that the client needs to file their U visa will be included in the referral packet that we send you. If for whatever reason something's missing, we will let you know. Also, if something might be outdated, we can also let you know. For example, you have this pay stub from 3 months ago, you might want to ask the client to get a more updated one. But we will guide you through all of that. Our sample filing has examples of documents that you can include, and we also have document lists that you can look at during that initial client meeting. Okay, so now you know more or less what the client meetings will be like, what types of documents and evidence that you'll need. So let's dive into actually filing the U visa. So, and for the most part, you'll have the principal applicant, the person who is either the direct or indirect victim of the crime. And in some cases, you might also be working with derivatives or family members. We will let you know from the get-go. Whenever you accept a case, you'll know how many cases you're accepting. For the most part, it's just the principal applicant. Every single U visa applicant, whether principal or derivative, will need to have a cover letter, an index where you list all of the documents that you're submitting, the immigration forms, the actual applications, and the supporting documentation. And so you can look at what that sample filing looks like at the end on our website. We have a sample. Okay, so now let's take a look at exactly what those forms are. So the cover letter and index are pretty straightforward. This is where you, as the attorney of record, will be able to explain to USCIS and really advocate for your client and explain why they were a victim of a qualifying crime and how they meet each of the 4 requirements. Again, this is probably the only opportunity you'll have to really make those arguments. It is more of an argumentative document than just, a cover letter saying, here is the U visa. Then you'll have form G28. This is an immigration form that notifies immigration that you're the attorney of record. For U visa, it's only 1 form per applicant. And if for whatever reason there does need to be a change at any point, we can guide you through how to submit that change of address. Because for U visas in particular, there's a separate service center that we communicate with. A lot of these can be done online if you do other types of immigration work, but for U visas, because of the confidentiality protections that Katie was mentioning earlier, communication with USCIS is a little bit different. Then you'll include the form I-918, which is a U visa application. This form will ask questions about the crime that occurred, where it occurred, all of that. For principal applicants, you'll also include the supplement B U visa certification form, and it must be the original. This form is filled out by law enforcement, as Katie mentioned before. And then you'll also include the waiver of inadmissibility if the client is inadmissible. Not all U visa applicants are. I would say a good chunk of the cases that we refer to pro bonos do need the waiver of inadmissibility. So you'll have to prepare that form. And then lastly, you'll have to prepare the work authorization form, which is the form I-765. And in cases where an applicant does need to request a waiver of inadmissibilities, if they are unable to pay the fee and qualify for the fee waiver, then you will also need to fill out the fee waiver application. And if that's needed, all of this information will be in the referral packet. We will let you know which documents support which applications so that you know ahead of time what you're getting into. So those are the cover letter and forms. Then in terms of supporting documents, you'll need, again, that affidavit. You'll need documentation supporting their U visa eligibility, proof of identity, and if they need a waiver of inadmissibility, all of the documents in support of that application. And I will say here, in cases where the client also needs that waiver of inadmissibility, their affidavit should also talk about why they merit a positive exercise of discretion on that application. So the affidavit won't just talk about the U visa and the crime that they were a victim of, but the affidavit will also explain why they merit that the waiver be granted in their favor, why they should remain in the US for the duration of this process. Okay, so moving on to derivatives. What do derivatives need? It's very similar to the principal applicant's list of documents, but I do want to highlight just a few differences. So the first one is their U visa application for derivatives is the form I-918 supplement A. And because they're derivatives, when it comes to supporting documents, the main piece of evidence that they'll need to include is proof of their qualifying relationship. So if you're talking about the spouse, you want to include that marriage certificate that demonstrates that they're a qualifying family member, or if they're a child, the birth certificate listing the principal as a parent. Something else to highlight that's different is that U visa derivatives do not need to show that they meet each of the 4 requirements for the U visa because they were not the victims of a crime. So you don't need to include a police report, you don't need to include the law enforcement certification because they were not the crime victims. All of that will go with the principal applicant's filing. And if they need a waiver of inadmissibility, then you'll also prepare that for the derivative. One thing of note here, and we'll be talking about this in some of the next few slides, is that derivatives need 2 work permit applications. They need the work permit for the U visa, which will be issued once the U visa is approved. And then they also need the work permit application for the stages before the U visa is approved, which I'm going to talk about in just a minute. So principals, you only need to include 1 work permit application, but for derivatives, you need to include 2. And if there's any questions about that at any time, you can always email NIJC and we can help you with that. Okay, so I was just talking about work permits. So U visa applicants, upon being granted non-immigrant status, become eligible to work in the United States. U visa principals are eligible to work inherently because of their status, which means they don't actually need to apply for a work permit. The fact that their U visa is approved as a principal gives them work authorization, and USCIS will automatically issue them a work permit based on their U visa. Derivatives are a little bit different. Derivatives, once the U visa is approved, they become eligible to request work authorization, which means that they do need to submit that form I-765 in order to receive a work permit based on their approved U visa. Due to the very long processing times, we strongly encourage applicants to submit the work permit application with their initial filing, as opposed to waiting until the U visa is adjudicated in order to save time. Right now, work permit applications for approved U visa, U non-immigrants is taking about 8 months. And so adding 8 months to already 8 years of waiting is a long time for clients. And so we just recommend you file that from the get-go. And in addition to that, so U visa principals, they're automatically granted work authorization. They don't need to pay for the work permit. They'll receive it upon being approved. Derivatives will need to submit that work permit application, and they will also need to pay for it, and it's $410. If they're unable to pay for it, you can request a fee waiver. Okay, and this can be incredibly life-changing for clients. You know, when they receive the work permit, they get a social security number. They can really start, you know, creating more stability in their life for their family. So whenever anyone gets a work permit, it's always very exciting, and it's great to be able to give that news to clients. Okay. So this, the next slide.
While we're looking at slides, we're gonna drop the first CLE code. You just did it?
We did it.
Okay, thank you, sorry.
No, you're good.
I do have a couple questions from the chat
Oh,
though,
yeah.
if you have one. First question is, if a U visa applicant is in removal proceedings, does USCIS retain jurisdiction of that case? And does the application stay the removal proceedings? And does the answer change if the person is a derivative instead of a principal? So I can repeat those.
Okay. So the first question was, if an applicant is in removal proceedings, who has jurisdiction over the U visa? USCIS retains jurisdiction over the U visa. The applicant, whether they're a principal or derivative, will remain in removal proceedings. Well, the U visa will not automatically take them out of removal proceedings, but someone who does have a U visa application filed or who has received some kind of decision, which we'll talk about later, the different types of decisions based on the U visa application, can then before the court submit either a motion to administratively close the case. In some cases, they can file a motion to terminate. In other cases, they can reach out to the government, to OPLA, and request that they be granted prosecutorial discretion, which ultimately results in termination of their case. In Chicago specifically, judges are very sympathetic towards U visa applicants who are in removal, and for the most part will agree to either administratively close or terminate proceedings for principal or derivative applicants who are in immigration proceedings. But the judge is not the person who adjudicates the U visa. That will always be USCIS. And I know this wasn't part of the question, but sometimes clients have removal, in absentia removal orders that they got before the U visa was filed. They can still proceed with filing the U visa. Once the U visa is approved, you'll have to reopen the case before the immigration court and request that the case be terminated. And we also have resources on that. And generally speaking, if a U visa applicant is in removal proceedings, NIJC represents on the removal portion, unless, of course, the pro bono wants to also take on that part of the representation. And we would also provide technical assistance with the court case in addition to the USCIS case.
Thank you. And then there's a separate question, not related. Does it help to include a supplement B from more than one certifying agency? For example, police department and child protection agency, or is it redundant and unnecessary once you have one certifying agency?
You only need to submit one supplement B. It's unclear whether USCIS would review more than one. In cases where an applicant is able to get more than one, you would make the assessment before filing. You would look at which certification is the strongest and then file that one. You also want to make sure that the person who signed the certification is actually someone who is authorized to sign it. We've had some issues with cases that are in civil court where they might not actually be a designated officer. And so we, before making the referral to attorneys, we look at the different certifications. Even before, when a client comes to consult with NIJC, we look at who they've reported to, what kind of agency it is, and kind of guide them towards the best agency to request that certification from. In some cases, you might get one from, let's say, law enforcement, a police agency, and it's not super strong, you file the U visa. If you get one later on that might seem stronger, we can talk about whether the next step would be to supplement or what to do with that stronger U visa certification. But generally speaking, you just need the one. And even if the applicant was a victim of more than one U visa qualifying crime, if the law enforcement agency just checked off one box, that's also okay. If they didn't check off every single crime that the person was a victim of, that's where you in your cover letter can do that additional advocacy and also show that there were multiple crimes committed. Okay, any other questions? All right. So if we can go back to slide number 40, we're just going to briefly talk about fees. So Katie mentioned in the previous section that the U visa application is free, so applicants will never have to pay for filing the U visa application, but the waiver application does cost $930. They will either have to pay for that or request a fee waiver. Likewise, the work authorization or the work permit for derivative applicants is $410, which they'll also either have to pay for or request a fee waiver for. Payments can be made in money orders, checks, or credit card, not cash. And if a fee waiver is needed, we would note that in the referral packet and guide you as to the types of documentation that the client should provide or has already provided in support of that fee waiver application. And I also did want to highlight these fees are true today, but they are subject to change. I know we've heard a lot that USCIS might increase costs or change costs. So it's always good to go directly to the USCIS website to check the costs before advising the client how much they have to pay if they have to pay. For the most part, NIJC clients are eligible for the fee waiver. So most of the cases that we place with pro bonos are cases where you will also be filing that fee waiver application. Okay, and so the fee waiver can be a tricky form because USCIS is very strict when it comes to adjudicating fee waivers, and that is the first form that they're going to adjudicate. So if you do, let's say, have to file that waiver of inadmissibility, you will know right away if the fee waiver was accepted or not, because USCIS will reject the inadmissibility waiver application if they deny the fee waiver. The U visa will still get receipted in, but it's just the waiver of inadmissibility that might get sent back to you if USCIS does not approve that fee waiver application. So there are 3 bases on which a person can request a fee waiver. The first one is because they receive a means tested benefit. This is not super common for U visa applicants, for the most part, because they're not yet eligible for public benefits. Their children who are US citizens might receive benefits, but it must be the applicant or the head of household who receives these benefits. So this is one of the less likely scenarios. The second reason to request, or the second basis, is if the applicant's household income is at 150% or below of the federal poverty guidelines. And USCIS does have a table on their website where they say what that threshold is depending on the applicant's household size. Most of our clients fall under this category. And so in order to demonstrate their eligibility, for the most part, they include tax returns, pay stubs, W-2s, proof of income. Not all of our clients file taxes or receive a paycheck. They might get paid in cash. And so this might include like a letter from their employer saying what their pay rate is and their hourly rate is. It could be bank statements. We have had to get pretty creative when filling out this application. And so when in doubt, just reach out to us for assistance. And then that last basis is the least likely, and it's not one that we see very often at NIJC. So this one is demonstrate financial hardship. So this is in cases where an applicant maybe has the income to pay for a fee, but there's circumstances in their life that prevent them from having that money. Let's say they might have an illness that requires them to spend all of their paycheck on medication and doctor's visits, and therefore they're unable to pay the immigration fees. It's very, very unlikely that this will be the basis for any fee waiver application that you're filling out, but it is on the form. So just pointing that out. So These are the fee waivers, and the forms, the documentation that you'll need to fill this out should be part of the referral packet as well. Although it is the documents that become outdated the fastest because you want to include current and up-to-date proof of income for the applicant. Okay, and now we just have a few filing tips. These are general, there are no order in particular. But the first one, when it comes to documents that are not in English, they should be translated. The translation should be certified. It does not have to be notarized though. And so for the most part, this is birth certificates, marriage certificates, divorce decrees, but it might also be letters of support. It could also be documents from home country, diplomas, things like that. Second, USCIS forms. So for those of you that already work within immigration, you know that USCIS routinely updates forms. And so it is best practice that before you start filling out a form, you download the form directly from the USCIS website to ensure that you're filling out the most up-to-date form. If you end up filing a form that's out of date, USCIS will reject that application. And as we know, the law enforcement certification is only valid for 6 months. And so that can have, a rejection can have a detrimental effect on a client's application. So always, 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 when in doubt, go directly to the USCIS website. Next is just how to put the application together. So there's a few different ways to do this, but at least at NIJC, we do hole punch the top of the application and then use prongs to fasten everything together. If you're working with more than one applicant, be sure to fasten each application or each individual's applications separately. Even if they're part of the same family unit, we want to keep them separate because USCIS will adjudicate them separately. Can I see a question?
Yeah, I have a question about the metal prongs. USCIS came out with like a policy of like, don't attach things. Do you still do that to make sure that these are held together?
Yes, so USCIS did recently issue a statement saying that they don't want paper clips, they don't want any kind of fasteners or anything holding together applications, but we are very nervous about following that because USCIS might lose things and these are really important documents. So until they come out with a more formal policy or advisory, we're going to continue to hole punch and fasten applications together. So if that does change, we'll put that on our website. We'll let any pro bono partners that we're working with know. And as we review draft filings, we will also let you know of any updates regarding that or anything else that USCIS might have updated. And lastly, just setting up the application. Using a trackable delivery service is really important, especially if you're cutting it close to that expiration date. We want to have proof that it was delivered on time. And for USCIS purposes, they consider it on time if it was received by the date. So let's say that the law enforcement certification expires April 4th. USCIS needs to receive it by April 4th. It's not the date that you send it out, it's the date that they receive it. So that's just something important to keep in mind. And again, applications should be per individual and not per family unit. And then where to file. So again, this is current as of today, but it is also subject to change. USCIS likes to update their filing locations, and filing location also varies depending on the courier service you're using. So always refer back to the website to make sure that you're filing at the correct location. These are all things that we will also check as we review drafts. And so if you're, for example, working off a cover letter that might have been used a few years ago, as I review drafts, I have like my checklist where I'm looking at all of this. So it's good to have another pair of eyes, but best practice, refer to the USCIS website for these types of logistical details. Okay. Any questions about preparing the application packet?
So there is a somewhat case-specific type question here that I'll pass along. In this person's office, they are interested in trying to protect victims of what is often called notarial fraud or deceptive lawyers. And by obtaining certification of a qualifying crime, for example, extortion, witness tampering, obstruction of justice, and then file that with USCIS. While there are examples of successful cases of this kind, a major obstacle has been the requirement of substantial abuse, physical or psychological harm, and in particular, the USCIS regulation at 214.14, A14.2. Do you have any information about the reason that USCIS decided to impose this special extra burden of proof for only these crimes? The Federal Register at the time really makes no sense. Are you aware of any advocacy efforts to try to get USCIS to rescind or modify this regulation?
I am not aware of any advocacy efforts specific to that ground. I do know that Assista is a national organization that does a lot of U visa advocacy. They also offer technical assistance on complex cases, and they often submit amicus briefs if an agency does decide to sue the government for these types of like changes in regulations. They might be a better organization to reach out to, or their website might have more information about that. I do know that for whatever reason, USCIS is a lot stricter when it comes to adjudicating U visas where the qualifying crime is based on extortion or blackmail. I'm not sure what their reasoning is behind that. I don't know if you have more information.
No, I don't. And I don't know anything about advocacy either. I think, you know, the closest thing that we could find would be reviewing BIA cases about that topic.
Yeah, BIA cases or appeals.
Yeah, AAO appeals, exactly.
Any other questions? No? Okay, well, I am going to give the second CLE code at this time. The second code is cooperation. Cooperation.
That was the
Oh,
first
that was
one.
the first one. Oh, gosh, I'm sorry. The second one is helpfulness. Helpfulness. Okay. So now we're going to talk about what happens after you file the U visa. So this is probably the longest part. All the hard work at this point has been done. You've prepared the filing, you've submitted it. Now comes the long wait, but there are some things to expect as you're waiting. So the very first thing that you'll receive after you file are receipt notices. These, you will receive one notice per application that you file. So it'll be per the U visa application, per waiver of inadmissibility application, and per work permit application. Additionally, as the attorney of record, you will be receiving both the client's copy and your copy. So it'll be a lot of mail within the first few weeks of submitting that application. Upon receiving that, you'll want to reach out to the client and get their copies to them. Some things to look out for on those receipt notices are the received date. You want to just make sure that USCIS did in fact mark it as received before that U visa certification expired. And the second thing you're going to want to look out for or take note of is the receipt number. So USCIS will assign a unique receipt number to each application. This number should be on all correspondence you receive from USCIS. And if at any point you do need to reach out to USCIS to make an inquiry, to ask for an update, you're going to have to include that receipt number in your correspondence so that they can locate the application. So after you've received the receipt notices, a few weeks after that, you'll get the biometrics notice. The client will have to attend a biometrics appointment where an officer will take their photo and take their fingerprints. This is basically an FBI background check. It's important to give clients a heads up about this in case they weren't truthful about their criminal history. And it's a very quick appointment. Attorneys are not required to accompany clients to this appointment. But since you do receive the client's copy of the biometrics notice, it's important that you reach out to the client as soon as you receive it so that they don't miss that appointment. Missing the appointment will cause delays in the adjudication of their case. Bless you. And if for whatever reason the client is unable to make it to the appointment, or you get the notice too late and you aren't able to contact the client, let us know because we can help you get that appointment rescheduled. Then comes probably the longest wait. We're looking at about 5-year long wait before you receive anything else. And at that point, you'll either receive a bona fide determination notice, which I will explain what that is in the coming slides. You might get a request for evidence. USCIS might want more documentation to be able to adjudicate the case, or you might get a waitlist notification. Regardless of the correspondence you receive, it's important to always contact us so that we can keep our records up to date. And if it is a type of correspondence that you need to respond to within a certain amount of time, we can help you prepare whatever needs to be submitted. And then about a year or two after that, you'll get the actual adjudication, the decision on the U visa. And so as you can see, the wait time is very long. It's about 61 months right now for the U visa. And a lot of things can happen during this time, especially for our clients, right? They can move, they might get married, depending on their situation. It's possible they have, a new arrest. Lots of things can happen. We've had situations where clients decide to move back to home country. There could be a lot of things that might affect their case. And so it's important to check in with clients, maybe every year, every 6 months, just to make sure that everything's going well. If an update is needed, there is a specific way to reach out to USCIS to provide them updates. And so you can always reach out to us and we'll help you draft whatever needs to be updated. And also it's important, again, to manage client expectations at this stage, because they might be hearing that people are getting work permits sooner, or that, my cousin heard, that this attorney got them their U visa faster. And so it's just good practice to be in touch with clients at this stage and just let them know everything is proceeding normally. It just takes a really long time. At the same time, if anything changes with your either representation, your address, did you switch firms? Can you take the case with you? Anything like that, it's also important to let us know so that we can guide you in how to keep USCIS up to date with that. Perhaps a new attorney is taking over the case. It could be anything, but it's important to update all of that with USCIS. Okay, so earlier I mentioned the bona fide determination. So this is something that is relatively new for U visa applicants. It's about new as of 2 years ago. So USCIS acknowledged the incredibly long wait time or adjudication times for U visas. And so in an effort to alleviate that wait time, they created what's called the bona fide determination. So basically, an officer has a checklist and they check an application against that checklist. And if an applicant has included everything that's on that checklist, they'll issue a bona fide determination notice. And that notice grants the applicant deferred action, which is protection from deportation or being placed in removal proceedings. And it also grants the applicant employment, the ability to request employment authorization. So right now we're seeing that the wait time for U visa bona fide determination is about 4 years from filing, which is still a long time, but at least during this time, an applicant is able to work. The work permits that USCIS issues based on a bona fide determination is valid for 4 years and can be renewed if needed. Although so far we haven't worked with any clients that have had to renew because they've gotten their U visa before it expires. So one thing to note about the U visa bona fide determination is it's not an assessment on the merits of the application. It's just that checklist. Are the forms there? Is there an affidavit? Is there identity documents for the client? They're not actually looking at the details of a case. But we have seen quite a few clients receive this. And this is also one of the reasons that we recommend that you include a work permit application for all applicants from the get-go, because if they are issued the bona fide determination and you included a work permit application with that initial filing, USCIS will automatically issue them that work permit once they issue this notice. If let's say you forget or you're unable to include that work permit application at the time of filing, then you'll have to wait until you receive the bona fide determination to file that work permit application for the client. And that can take, another 6 to 8 months for the client to get that work permit. One good thing about this U visa, the bona fide determination work permit, is that it's free. Clients don't need to pay for this, whether they're principal applicants or derivatives. Okay. And I think I got a little bit ahead of myself, but this kind of has the benefits of the bona fide determination. A bona fide determination is not an adjudication, so the case still needs to be adjudicated by an officer. And if a client doesn't receive a bona fide determination, it's not necessarily a bad sign. It doesn't mean that their case won't get approved. It doesn't mean necessarily that anything's missing. Just means that whoever was, reviewing that checklist maybe thought that there might have been something that didn't warrant a bona fide determination. The applicant could still get a deferred action and a work permit based on being placed on the U visa wait list, which is the next slide. And so Katie mentioned when she was explaining what the U visa is, that there is an annual cap of 10,000 U visas. And the reason for these long wait times is because many more people apply for a U visa. And so since the government can only approve 10,000 U visas per fiscal year, if they get to an application and they actually review it and adjudicate it on the merits, and they determine that it's an application that's approvable, but there's no more U visas available for that fiscal year, they'll issue a waitlist notice, basically saying, we reviewed your U visa, it's approvable, we just can't approve it just yet. And so that notice will let the applicant know that they have deferred action and that they also have a work permit. So we're seeing this less we've been seeing this less since bona fide determination started being issued by USCIS, but this is still something that USCIS does put into practice. So issuing this work permit based on being placed on the wait list. And the notices do look different. So if you do receive them, you should be able to identify which is which, but if not, we have samples and can help you make that determination. Okay, and then the next slide, keeping in touch with the client. I've already mentioned this. Just make sure that everything is up to date. If there's any changes for the pro bono attorney or the client, they need to be reported. Applicants do have the requirement to update their attorney with USCIS within 2 weeks of moving. This is a requirement that all non-citizens have until they naturalize or become citizens. And so if your client does tell you that they've moved, you do need to update their address with USCIS. Okay, so now the long wait has ended. You finally received news. What happens then? So you will receive an approval notice for each application that you've submitted. So again, this is very document heavy. It'll be a big mail day. You'll receive 2 copies, one for you and one for the client. You'll receive a work permit for the U visa principal, and if you're representing derivatives and applied for work permit authorization for derivatives, then you'll also receive the work permit for them. And you'll receive the waiver of admissibility approval notice as well. So what does it mean to have the U visa? So just yet, clients are not able to travel internationally. They are able to move within the United States, travel within the United States, but this is not yet a visa to travel, to leave and come back into the US with. If you're representing someone who is outside of the United States, they can then move on to the next step, which is a consular processing step. And at that point, NIJC can take the case back for the consular processing, unless, of course, the attorney wants to also assist the client with that. After the person has been in lawful and valid non-immigrant status for 3 years, they become eligible to apply for adjustment of status, which is to receive a green card. Clients often come back to NIJC for that, and we assist them with that process. And eventually, they could also be eligible for naturalization or citizenship. It's very important to make clients aware of these new rights and responsibilities once their U visa is approved. We have template closing letters that kind of go through all of this, remind them when they need to consult with an immigration attorney to assess their adjustment of status eligibility. If they're unable to adjust status, then we can also guide them through extending their U visa status. But all of this should be in a closing letter that you send to the client, and we have drafts for all of that. So that brings us to the end of the substantive portion. Are there any questions about this? I know it's a lot there.
Do U visas have an expiration date, or are they do?
Yes, so U visas are granted for 4 years, and they can be extended for certain extenuating circumstances, but for the most part, it's just those 4 years. And upon being in U status for 3 years, the applicant can then adjust status to legal permanent residency.
So at the end of 4 years, and then all the time in between that you're waiting, so like the 5 years or so, that isn't counting towards it, then it's granted, you get the additional 4 years, and then you have to reapply, or then you have to apply for, if you haven't applied for like a green card or something like that, is your status just done in the United States and your visa's expired, you have to leave, or do you have to, are you excluded?
While the U visa is pending, applicants don't have any lawful status. So that the time, the 8 years that USCIS is taking to adjudicate U visas, they don't have any type of legal protection until they receive either the bona fide determination notice or the waitlist notice, at which point they have deferred action. Once they get that U visa approval, it's valid for 4 years. If for whatever reason, they're unable to adjust status at the 3-year mark, depending on the reason that they were unable to adjust status, they may be able to request an extension of the U visa. Usually extensions are for 1 year. It may vary depending on the situation. Ideally, a person would file the extension before the U visa expires, although we have heard of situations where a person might have let their U visa expire. Maybe they were still in a situation of DV. It could be for a variety of reasons. Some people have been successful in extending their status even after the U visa had expired. They don't need to apply from scratch though. It would be an extension. Any other questions? Okay, well, these next few slides have resources to regulations, statutes, has a USCIS website where you can download forms, check fees, processing time, filing addresses. There's some organizations that we list here that often publish practice advisories or provide assistance. I mentioned Assista before. Our address is on there. National Immigration Project, Immigrant Legal Resource Center. These are all great resources if you want to learn more about U visas or have questions about specific issues within a U visa. We also have the contact information for the Vermont Service Center, which is a USCIS service center which adjudicates U visas. The email that's on this slide is the email you'll use to communicate with USCIS. For other types of processes, you might be able to do an InfoPass appointment or call the customer service hotline. For U visas, due to the confidentiality protections, the email is the only way to communicate with USCIS. We have a few other resources there, and then we have our contact information for our project. If you have any questions about U visas, VAWA, or any of our pro bono projects or NIJC in general, you're welcome to reach out to us. Again,
One question, are the slides going to be available for download?
yes, we will be sending a follow-up email with the handouts and the slides. It will include the link to the survey. A lot of the handouts are also available on our website. You can download them there. We do occasionally update them depending on updates from USCIS. But yes, the slides will be made available to everyone who attended.
And the PowerPoint was sent out in the initial email this morning. Some people couldn't receive it because it was too big. So if you're one of those folks, you can just email me back and let me know, and I'll send it to you a different way.
And we do have our Human Rights Award on June 6th. We hope you all can attend. There's a registration link in the PowerPoint. And there's also a QR code to the survey for today. It's part of the PowerPoint as well. If you can just scan that if that's easier.
Just say for that QR code, if you want CLEs, you need to complete that evaluation. So that's where we're taking the CLE credit from, and where you can put in your CLE code word. So it should work on your screen now if you want to take out your device and just do that. Otherwise, Katie will also be sending around a link, but you have essentially 3 business days to register for your CLE credit.
Well, we are a little ahead of schedule, so I think we'll go ahead and do the first case example, Maria. It's put what we can enter on into practice.
Yeah, so I'm gonna go ahead and I'll read the case example. So we can keep in mind the 4 requirements that we discussed earlier today. You may also want to be thinking about grounds of inadmissibility, if there's any to waive, and perhaps any potential derivatives. So case example 1, Maria. Maria is a citizen of El Salvador and entered the United States by crossing the border with a group of people she did not know through Mexico in 2010. The first time she tried to enter, she was stopped by immigration and returned to El Salvador. She entered successfully a few weeks later and had no contact with immigration. She met a man at work who was also undocumented, and they married in 2013. They had 2 US citizen children together. After Maria's daughter was born, her husband became jealous and began to drink heavily. In one incident, Maria's husband was intoxicated and he began smashing their dishes in anger. He threw plates and cups at Maria and she was injured. She called the police for help, gave them a report of the incident, and her husband was arrested. Maria got an order of protection against her husband and does not know if he was ever prosecuted for the incident. So in taking a step back, let's begin with our very first requirement. What is the qualifying crime? For any of our folks in the room, feel free to shout it out, or online, you can put it in the chat.
Domestic violence.
Absolutely. Domestic violence. Right. So here we have this one very specific incident, this explosive event that happened. Who could qualify or who could certify this crime? Who might be able to sign that form I-918B? Right, the police department, perhaps the state's attorney given the order of protection. So there might be 2 viable options there. In looking at who committed this crime, who was the perpetrator, does it matter that her abuser is undocumented? Does it matter that he does not have a legal status himself? Right, I see head shaking. No, that doesn't matter in this case. Does it matter that she's still married to him, that she's still married to abuser? Right, that also is not taken into account with her eligibility. And then in moving on to grounds of inadmissibility, may Maria need a waiver? Do you see any grounds that she might need a waiver for? I see some nodding. What do you see? What comes up for you? Right, entering without inspection. And there's one other one here potentially. Feel free to put in the chat as well. So at this time, when she first tried to enter and then was stopped by immigration and returned to home country, she may have a potential expedited order of removal, and that may also be another ground that needs to be waived. We can also think about how might she present her waiver application? What all may she use as mitigating factors or positive elements for her case?
So someone asked, what if she obtained a civil order of protection?
So in cases where it's a civil order of protection, you'll want to reach out to the agency and see who the head of the certifying agency is. There is a section in the INA that defines who a certifying agent or what a certifying agency is, who can be the head of the certifying agency, and who can be people designated by the head of the certifying agency to sign off on these visa certifications. And so a civil order of protection isn't necessarily a bar to getting that law enforcement certification, but you'll want to check in that specific jurisdiction, who is the head, who have they designated as certifiers, and does that agency fall under the definition of law enforcement agency as stated in the regulations or the INA. So it's not exactly a yes or no answer, but it depends on the jurisdiction.
Any other questions from the chat that have come in? And so in thinking about, as Maria presents her waivers application, she can highlight that she has 2 US citizen children. If she's a sole caretaker, she can also highlight that in her application. Here we don't have some of those details around substantial harm, perhaps emotionally, although she could be working with a counselor perhaps to flesh that out. But here we do know that she was injured. And so she may have photos of her injuries, or maybe she went to the hospital or to the doctor, and those are all elements that could be included as well. Any other questions about case example 1?
Well, thank you so much to everyone who attended in person and virtually, and special thanks to Baker and McKenzie for hosting us, providing lunch, and Melissa for helping us coordinate all of this, and Angelique who spoke such kind words at the beginning of our presentation. Again, if anyone is interested in taking on a case, one of our handouts does include a list of cases that are currently available for assignment. We are getting a few more in. So please check our website if you maybe aren't able to take a case at this time, but in like a week or 2 weeks, a month or so, those are updated on a monthly basis. You can also sign up for a pro bono newsletter. That will also include the list of cases, not just from our project, but from all of NIJC's pro bono projects. But if you have any questions about the presentation or about our work, partnership, anything like that, feel free to reach out to any of us who are here today. Our contact info is on one of the slides. Thank you.
Yeah.